And we have applied on 9th of September upon the instruction of the client. It's a second appeal.
My lord, may
Oh, my lord, it's a first appeal. It's the first appeal. Okay,
My
my
lord,
lord.
may I
Okay.
be permitted to
Thank you,
mention a
madam.
matter for extension of interim order? The interim order. Yes, ma'am.
My lord, may I mention my own case? It's a review matter for recording my submissions. This was an assigned bench assigned to this bench, my lord, Honorable Justice, Chief Justice, Mr. T.S. Sivgano. So I have been.
We need to reconstitute the bench. So we'll do it.
But my lord, I
give
have
us some time.
But my lord, I have to go to Supreme Court because neither Bhubaneswar nor Delhi is taking this case. They are saying DVC is in Kolkata, you are in Kolkata, unauthorized absence is in Kolkata, then how can you file it here? You go to Supreme Court. I went to Supreme Court, they said you have to get it recorded. Your submissions has to be got recorded.
No, the review.
And I mentioned it, my lord. May I complete, my lord? If you, my lord, permits, then I'll complete.
No. The review, this bench has to be reconstituted because the then Chief Justice sat with another honorable judge, passed the order. So that bench has to be reconstituted. Just
I understand, my lord, but
we'll reconstitute.
My purpose, my lord, I am without any money. They are not given
us
the money.
I just assume office today. Just give us some time. I will.
Okay, my lord. You'll be mentioning next week.
May I have your lordship's kind leave to mention a matter for correction of your lordship's order, my lord?
What correction?
My lord, there is, my lord, your lordship was kind enough to pass an order directing the learned civil judge, senior division 8th court at Alipur to, my lord, have the matter released. It would be 7th court, my lord. Instead of 8th, it is 7th, my lord. I have
correction.
My lord, may I submit one more line? I was directed, when I mentioned it on 9th, I was directed to file an application. You said it was not be done. I have already filed the application, my lord.
Application to kiya cha,
Application.
Sure, absolutely. Yes, please call the list.
Appellate side, Delhi list, serial number 1.
Lord, may I mention one more matter? On that day, your lordship has been pleased to correct an order, but in that order also there is some dispute in dates. My lord has pronounced some other date which has been challenged before lordships. That date has been set aside. Thereafter, your lordships has been pleased to dictate the correct date, but unfortunately, the order sheet both dates have been typed, so it is creating get confused. So let the first line be written from the paragraph.
No, are you mentioning upon notice?
This mentioning is not.
No, please mention upon notice. Please mention.
I'll
and indicate the corrections you need.
Lordship, I'll do that. Lordship.
Serial number 1.
Lordships, I am appearing on behalf of appellant, but just now, yesterday I have received this appeal.
You are appearing for the appellant?
Appellant not appeared, that's why your lordships directed to legal aid to.
So you have been instructed to appear. You want time?
Yes, lordship. At least 7 days,
Very well.
lordships.
Where is your letter of appointment? Where is the letter of appointment? You have been given a letter of appointment?
Yes, lordship.
You have a copy of the letter of appointment? It is not on record, that's the reason.
প্রথম পেজটায়
Will you appear for the respondent, please?
I appear for national road. There are
But
others.
you accept it, otherwise again there's a problem.
Lordship will kindly, my lord.
Srimati Shima Ghosh, Land Advocate, appears and submits that she has been appointed by the High Court Legal Services Committee, Calcutta, pursuant to her earlier order to represent the appellant. The respondent is not represented. We request Mr. Rajesh Singh, that counsel who usually represents the respondent, to appear on behalf of the respondent. The matter is adjourned for 1 week. Please take it. Next,
Serial number 2,
My lord, this is a insurance appeal. My lord, your lordship would be kind enough to, my lord, send it to mediation. My lord, like other matters, my lord had been kind enough.
in this matter, my lord, I have filed Vagalatama for the claimant respondent number 1, my lord. After filing, it came to my knowledge that by order dated 9th September, it was
send to
sent,
the, yes.
my lord,
So you have been appointed by the,
by the claimant respondent number 1.
no, but you did not
No, no,
appear, so,
I have filed Vagalatama for claimant
but if
respondent.
you do not appear, then we cannot help it.
Yes, yes, my
If you
lord.
are absent, then what we can do?
Now, my lord, unless my Vagalatama is permitted, I can.
True. But if you are
Yes.
not there, that's where you directed very well. You are appointed. You are
Yes,
appointed.
Now, as lordship
No.
thinks,
If you have filed a Vokalatnama, then you should appear on the date.
filed
Several dates you did not appear.
filed yesterday, my lord. Filed yesterday.
Yeah.
Vagalatama filed yesterday.
Where is your Vokalatnama? আছে এখানে ট্যাগ আছে? তো ট্যাগ হবে তো এখানে সব। এখানে আসবে না। Vokalatnama file
Filing number now not available. It will appear in the status.
স্ট্যাটাসটা দেখে নাও তো। এটাই দাও। It's a such and such appears
আপনার কি নাম?
and submits that
কন্ট্যাক্টটা দিয়ে
he has been engaged
9830
by the respondent award holder
777
present him in
নাম
this proceeding. Due to the absence of the respondent,
ঠিক আছে লিখে নিলাম
we directed the Secretary Calcutta High Court Legal Services Committee to appoint an advocate to represent
My lord, I'm for the appellant insurance company, my lord. I'm praying for short passover.
Passover. Then not today, maybe.
No, my lord, short passover will do, my lord.
Not Passover, very well Passover.
Grateful, my lord.
Next.
Serial number 4, SF7.
Second appeal, yes.
Second appeal, my lord, I am the defendant. My lord, this is judgment of reversal. Now, my lord, the appeal, the court has reversed the judgment of the trial court and held that my lord, the deed of Orponnama is a product of fraud. While the learned trial judge, my lord, held it no, there is no, my lord, as such anomaly, since the, my lord, attesting witnesses, my lord, have admitted the due execution attestation of the will of the Orponnama, it cannot be. Now, my lord, the learned appellate court has reversed it and the decreed the suit in its entirety.
Sorry?
Decreed the suit in its entirety. Now, that is the whole difficulty, my lord. I am before your lordship.
So on the same set of facts, two different courts have arrived at
Two different findings, my lord. And my lord's judgment is there, my lord, registered document 68 complied with, it carries a presumption with it.
No, so trial court, what did the trial court say?
Trial courts, trial
court set aside the.
No, trial court, my lord, set aside the, my lord, it was in my favor. Trial court held that is the Orponnama is a genuine document. It was in my favor. The suit was dismissed. Now, my lord, the plaintiffs preferred the appeal.
No, the plaintiff asked for a declaration that the Orponnama is void.
Void.
Cancellation of Orponnama.
Cancellation, partition, and their declaration of title.
So cancellation was not allowed.
Not allowed.
So trial court.
But the declaration was allowed to some extent, which to the properties which are not covered under Orponnama. That portion
That
was
is for the purpose of partition.
Partition.
Now, if the Orponnama goes.
Entirety, my lord, I am nowhere.
No, but if the Orponnama goes, remaining properties
will be partitioned.
So the part, it's a part reversal.
Yes.
It's not a reversal in totality.
No. And now, my lord, I am the Shebayat, respondent number 1, who only, my lord, defendant number 1, who only, my lord, contested the suit, and my lord, it was, my lord, given to, my lord, the deity. After the, my lord, this lady Shakuntala, after his husband's death, after her husband's death, she was tortured, my lord, by the in-laws. Now, my lord, although she lived there, but after, my lord, natural calamity, the house was completely broken. Now, the case made out is the defendant number 1, who was the priest of, my lord, the plaintiff's family. My lord, the Jew, my lord, the deity was installed in the priest's family. Thereafter, my lord, he created an Orponnama. If your lordship would kind enough to, my lord, come to the appeal court's judgment, my lord, the first finding is the onus of proof was upon us, being the defendant. My lord, the burden is upon the plaintiff. If the initial burden is shifted, then onus lies upon us.
No, so burden has not been, according to you,
exactly. First finding is, since you are asserting the right in the Orponnama, it is your duty to prove. Burden is initially upon the plaintiff. Yes. Then, my lord, if he discharges, then ownership is upon the defendant. I'll show that finding to you.
He said that the Orponnama was registered at a sub-registry which is beyond the jurisdiction of the property.
But it was registered. It was registered. It was registered. The registrar accepted it.
No, registrar will not decide whether there is any.
The jurisdiction, the registrar will not see, my lord, that is the case, my lord, we see on that date, my lord, Usti and my lord, the two registry offices were functioning with one registrar, and my lord, registrar at Usti was having jurisdiction. That may be an irregularity, not illegality.
What is the substantial question of law? Registration beyond jurisdiction.
My lord, that may be an illegality, not irregularity, not illegality.
But we don't find any.
My lord, not drafted, my lord, from my Sheresta, my lord.
What is the substantial question of law?
Lord,
Tell us.
Millard, one Millard, then 68 has been complied with Millard, whether registered document Millard, whether it can be
No, section 31, we can ask for, they can ask for cancellation.
that is true,
So
but that was not the appeal court did not go into that line, Millard.
section 31 is a power of
Power
cancellation.
definitely,
So
but
where is the substantial question?
not happily drafted, Millard.
To tell us what is the substantial, we do not find any question is substantial.
Millard, kindly see Millard the appeal court's judgment, Millard. Kindly the kindly comes to page 10 of the appeal court's judgment.
No, tell us what is the substantial question of law.
Millard, first, Millard, this accordingly, Millard, kindly page 10, it's the third paragraph, it says, accordingly, law suggests owners of proving the Orpon Nama deed upon the defendant number 1 and not upon the plaintiff. Patently, Millard, illegal. Patently, Millard, can't be. And court proceeded on that basis. Can't be. And Millard, the attesting witnesses say, Millard, the lady put his Millard fingerprint in front of the witnesses. The identifier identified her. The learned appellate court had came out with a third case, which is neither pleaded in the
But if Shakuntala Mondal was never present at the office at the place of registration, and if on the document a fingerprint was
kindly see the document. Identifier was there. It was accepted. Kindly see, this is the last page. Execution is admitted before the registrar. Kindly see, Millard, this is the document, last page. Execution না নেই নেই নেই
Five.
Yes.
My lord, item number 5, my lord, I am appealing on behalf of the
Sorry?
appellant, my lord. My lord, I do not want to proceed with the appeal. I have a written instruction. I am withdrawing my appeal. Because, my lord, the appeal will not lie. The suit for 2G and, my lord, the original tenant died before the 2001. That is why.
Thank you. A fair
Yes,
suggestion.
my lord. That is why, my lord, I am giving you the written instruction, my lord.
Yes, stay down.
Yes.
The learned counsel for the appellant has fairly submitted that the greatest impediment in the appeal would be section 2 bracketed B. Yes, next.
Deeply appreciate.
For the case. Acha, acha. Affirmation or reverse?
affirmation, my lord, eviction suit, my lord. What defended. So, my lord, only one thing, only one thing, my lord. I don't know whether this will cut, my lord, much ice. My lord, I was reading the statute section 6.
You yourself convinced that it will not cut an ice.
No, my lord,
So how long will it take to vacate it? Tell us.
that
We give you time till 31st December.
running business. if they will, my lord, ultimately that is a commercial place. Anyway, my lord, one, my lord, point, my lord,
Oh, is that matter? Yes, yes, yes. I remember now.
substitution was allowed. That if your lordship,
Nothing remains.
if your lordship would kind enough to, my lord, see the section 6 of the Act, of the Premises Tenancy Act. If you once, my lord.
Yes, we have seen it. Take it out.
Once, my lord, kindly, my lord. As well as it goes to the, my lord, jurisdiction, inherent lack of jurisdiction, my lord. My lord, if your lordship once, my lord.
It was filed in the small causes court for small causes court for eviction of a licensee.
No, 6-4 notice, premises tenant. My lord, that's what, my lord, I am, my lord, showing it to your lordship. My lord, it will have bearing in other matters also. My lord, kindly see, it says on a suit before a civil judge. The opening words of it.
Premises tenancy.
But the small causes court has
Small cause judges of the small cause court, they are not civil judges. They are all district judges. They are all district judges. Therefore, my lord, small cause court, my lord, when that small cause judges are all district judges.
No. In small causes,
Even be that
junior divisions are
very well. Even that be so, they are not civil judges. They are governed by the Small Cause Court Act. One. Number 2, very well. If that be also so, they are, my lord, they are governed by the Small Causes Court Act. They are not civil judges. One. Number 2, my lord, if that be so, my lord, one is point of jurisdiction. তোমরা তো ব্যবসা করবে ভাই, এগুলো দিয়ে ভাড়া ফাড়া বাড়িয়ে করিয়ে নাও না, কেন করবে না? শুধু আফটার অল তো এত রেসিডেন্সিয়াল নয়। তো সেই লেট আউটই করবে, কি দরকার?
না না ও নিজে ব্যবহার করবে,
ও ভাড়া বাড়িয়ে করবে কারেন্ট মার্কেট রেট।
দিতে রাজি আছে।
কারেন্ট মার্কেট রেট দিলে কেন দেবে না? আপনারা নিশ্চয়ই ঝামেলা করেছেন।
6,000 টাকা ওখানে করে
6,000 টাকা ওই জায়গায় অত বড় ভাড়া হয়? বলো না। কোথায় অনির্বাণ কই?
It's a eviction on the ground of reasonable requirement.
Requirement default.
reasonable requirement, only on the ground of
Only on a reasonable requirement.
only on the ground
Only on the ground of reasonable.
that's the solitary ground one.
Help.
The judgment of
Serial number 9.
Alright, I am appearing for the respondent, defendant. 1,
You are for the appellant.
4 and 6.
I'm praying for a short passover, Your Lordship. Since Your Lordship, some
Yesterday
point
also.
in
Yesterday, my lord, he
Yes,
took
yesterday also
I'm,
you took a time.
I'm coming, rushing, my lord, every day in the morning.
You have taken time yesterday, so no Passover. Please tell us.
Since Your Lordship, the petitioner inter alia challenging the order, so dated Your Lordship 5th of March 2025. That is Your Lordship.
You have
Very
annoyed the
Lordship.
civil judge.
Yes, Your Lordship.
Yes.
Very Lordship, may I read the order, Your Lordship? Today is fixed for the temporary.
Partition.
Yes, Your Lordship. Suit for partition that was pending before the concerned trial court. But Your Lordship, the injunction order that was earlier passed by the Lordship trial court concerns, laterly that was refused with cost, Your Lordship. The injunction petitions under section under order 39 rule 1 and 2 read with Your Lordship section 151 of the CPC that was rejected, and Your Lordship 10,000 cost was imposed to the petitioners on the ground that the petitioner, Your Lordship, suppressed the materials of fact. So now Your Lordship, kindly come to the page number, Your Lordship, internal page of the Your Lordship, the memo. Here, Your Lordship, I have annexed the order. Defendant number 1 and 2, 1 to 7 appeared by filing Vakalatnama. They also submitted their written objection and written statement. Let the same be kept on record. Now the temporary injunction petition is taken up for the hearing and passing order. Heard both the sides. Defendant categorically submitted.
Self-same property, you have filed a partition suit.
No, Your Lordship. My humble submission is that, Your Lordship, I was not party. There, Your Lordship, in the partition suit being number 132. Neither I was party nor, Your Lordship, I made a respondent therein, defendant therein, Your Lordship. That was filed in my absence.
Given
However,
by the learned civil judge, page 183.
No, you see, the plaintiff now filed the present suit stating that the plaintiff of PS 132 already transferred his share in 2018, and since then, the present, if there is a transfer, you amend the earlier suit.
but Your Lordship, since I was
Earlier
not
suit, why the second suit is
Learned
required?
civil judge
what
has-
is the difficulty is that, Your Lordship?
It's no difficulty. If it is a devolution of interest, then the devolution.
Two partitions
Why,
should have been filed.
why the second suit is being filed?
But Your Lordship, that was the earlier suit that was filed in my absence. I didn't have the knowledge about it, Your Lordship. But Your Lordship, kindly come to the Your
Now,
Lordship
you
page
are
number.
not party in PS 132 of 2020.
Yes, Your Lordship. Kindly come to the page number
Are you
18.
a party in PS?
No, Your Lordship, I was not the party in that suit.
You are not a party.
No, I was neither the party nor Your Lordship. I made Your Lordship.
So you file an application for in the parent suit and ask for devolution of interest.
But Your Lordship, that suit was filed by Your Lordship a person who has already transferred the property in 2020.
That's why you transpose.
But Your Lordship, the injunction order, so for the injunction order as well, Your Lordship, the cost which was imposed.
No, in 2020, was any order passed for injunction? If there is an order of injunction passed already, that will operate in your favor.
That order of
that
injunction
was
refused in the earlier suit.
Kindly come to the Your Lordship page number, Your Lordship,
See,
142.
Second suit may not lie, or rather, he should have filed an application for substitution or devolution of interest. So whatever is there, transposition or addition, you are entering into what is the nature. So the second suit would go because if his transposition is allowed. If it is not transposition is allowed, then if he has any other independent right, and if already there is if in the earlier suit there is an order of injunction, that will operate. There can be two set of injunction over the same set of properties.
But Your Lordship, Your Lordship, may I, Your Lordship, submit one thing, Your Lordship? The difficulty is, Your Lordship, that the petition
Kindly place it 2 p.m. Lordship, kindly place it 2 p.m.
No 2 p.m. This cannot go on like this. Either you do it or we'll no further 2 p.m. please. This matter is being adjourned from time to time. Second appeal, either you are ready or you are not ready. Affirmation answer. Yes. No longer a tenant. Sit down.
Please, your lordship. My lord, am I audible, my lord?
Yes, yes, you are.
This is my lord, my affidavit of service.
Now, who is addressing? You are appearing for?
My lord, I am appearing for the respondent, my lord. My lord, I have received an instruction from the respondent, my lord, today that we have not received the copy of the Can 1 application, my lord, the stay petition, my lord.
Respondent, my lord.
You have not received?
No.
And my lord, we have received the memo of appeal, my lord.
Please give a copy and we come back on.
My lord, we are also praying a direction to file an affidavit in opposition, my lord. Then, my lord, can you fix it after the fact?
Why opposition? Settle the matter. What is the, you get the money, reschedule and
Yes.
finish off the matter. What did you say?
I'm ready to release the vehicle, my lord.
Say that it is
My lord,
13 lakhs approximately would be due towards any EMIs.
My lord, actually, when the vehicle was seized forcefully, my lord, there was the 3 installment that I was due, my lord. And after that, my lord, they forcefully took
Either
my
you
vehicle.
pay this, we send for this, or you continue with this. You pay this, you settle the matter. You want the vehicle or you don't want the vehicle.
Yes, my lord. But for my
very
lord, last 12 months, my lord, the vehicle has been seized and in their possession, my lord.
Yes,
And
so
that's
what
when
we say,
forcefully they have taken
in
away.
the
And
event,
there was,
no, see, in the event the respondent pays on his 8 lakhs, in the meantime, the vehicle should be released in favor of the plaintiff in a pliable condition.
Yes. My
If you are
lord, the
not doing this,
vehicle
we
also
dismiss
may
the
be in the
appeal.
damaged condition, my lord, because
Sorry,
for the 1 year it is not.
Then we dismiss the appeal.
This is my appeal, my lord.
Oh, sorry, we allow the appeal and do whatever we like.
My lord, if some consideration may be done, my lord, because for
We
last
gave
12 months,
we gave you the time to pay 8 lakhs. You have not paid.
my lord, some consideration may be done, my lord.
What
Because my lord,
consideration? Please tell us.
for last 12 months, my lord, the vehicle is in inoperative condition, my
last
lord.
12 months or last 13 months, we are not concerned when the vehicle was seized.
My lord, that was also forcefully, my lord, illegally, my lord. That was even my lord.
No, see, admittedly on that date, amount was due and payable. Correct?
My lord, 3
And
installment. That was like a 5 lakhs, around 4 lakhs amount was due, my lord. That was like a 3 installment, my lord. 1.2 lakhs into 3, like
what
a
was the amount?
3.6 lakhs. That was
my 4 lakhs at the time of my
yes,
receiving
yes,
the
my lord.
vehicle.
That was the
That
due,
time
my
of-
lord.
So
We are
let
ready
them
to
pay
pay that
4 lakhs,
amount,
they
my lord.
release the vehicle and then.
My lord, thereafter, my lord, kindly consider.
Sorry.
My lord, when they filed this suit, my lord, after seizing, my lord, after
lord,
4 or 6 months, my lord, they have filed this suit.
Very well. You want the money.
Some, my lord, 4 lakhs,
Very
my lord, is my lord.
My lord, we are
And
ready to
because
pay
your
all.
lordship has a vast experience in this, my lord, 4 lakhs. Presently,
My
my
lord, we are
lord,
ready to pay all
58
the installments, my lord.
The senior disappeared. Tell us. 5 lakhs within?
My lord,
My lord, my lord, am I audible, my lord? My lord, I am not able to start a video, my lord.
Okay,
Due to
very
some
well.
reason.
Very well. We need not to see you. Your
Uh,
voice is good enough.
Yes, my lord, 5 lakh will
Tell
be
us.
enough, my lord. My lord, we will be able to pay the 5 lakh, my
5
lord.
lakhs when? Within 2
My,
weeks?
my lord, I can take an instruction, my lord, from the respondent, my lord.
No, we will not keep it pending. Within 2 weeks from date, the
My
vacancy
lord, we will be able to pay within 2 weeks, my lord.
the Yes. Bolo.
Yeah, please, Your Lordship. My lord. This is, my lord, the judgment of affirmation. My lord, it's a suit for declaration and injunction. My lord, the original defendant, yes, Lordship.
You correct this. There are corrections to be made.
Correction, Your Lordship. The name
So
and
correct it. The matters, the matter is adjourned.
Please, your lordship. Lord, they had directed an undertaking to be filed by the. Now, the undertaking which they have filed, your lordship will see is absolutely contrary to the undertaking given earlier. Second of all, he has put in a power of attorney on behalf of two of the owners. No, not on behalf of the other owners. The power of attorney does not contain a clause authorizing him to give an undertaking to court. Second of all, these figures which he has given does not match with the previous undertaking. Totally different. Power of attorney 2022. No clause authorizing him to give an undertaking. Paragraph 5, Your Lordship, the tabular statement does not match what?
Just a minute. It's covered. Clause 9 and 11 covers it.
Which?
Clause 9 and 11 covers it.
Clause 9 and 11.
At page.
There is no specific undertaking for this purpose.
Any declaration he is entitled to.
No, this is
It's a filing an undertaking for us.
Allow me to file at least the exceptional affidavit. This is quite serious. He's coming up filing affidavits with different things. The tabular statement does not match. I have instruction. This is not what he says. There are tenants in the property. Litigations are going on over there. And also there are 5 owners. There are 5 owners. The property has merged by deed of merger. How can he give an undertaking on behalf of the 2 owners? There are 5 owners now. The Dhors and the Maliks.
3 owners.
No.
Litigation, my lord.
Litigation, not the property.
There are 3 owners, my lord. There was certain deed of exchange between 2 persons, my lord, other 2 persons, my lord. They are not the owners, my lord. So far as the property is concerned, 3 persons are the owners, 3% are parties to the suit. They have filed, my lord.
Who are the other parties?
No, they are not connected with this property.
are.
They are not connected
merged.
with the suit property.
Show the deed, please.
They are not
Show the
connected
deed.
with the suit property.
They are 100 square
We have
feet.
specific instruction, my lord. We will give him within 18 months, my lord. Let the
You have said so here.
my lord, we have stated.
No, 18 months. Have you
18
said
months,
so?
18 months. We have stated, my lord. That is there, my lord.
There is a deed of exchange
paragraph 3,
between
my lord.
both the owners.
But only he is
Property-
trying to obstruct. my
No,
lord.
I am not
No
trying to
purpose,
obstruct.
my
You are
lord.
making false statements.
No
and,
purpose,
And
my
also,
lord.
where is
Sir,
and
only
he's
will delay, my
where
lord.
is the instruction from the corporation? Because there is a direction to kindly see your
No,
lordship.
if they cannot give you in 18 months time, we'll pass certain orders. So you are
Let the appeal
No,
be
no,
kept pending, my lord. That is also
corporation
already, my lord.
interested in your possession and getting a portion.
I'll tell your lordship, this is not what he has stated on the papers. This is not what it is.
Are you giving alternative accommodation to them? Are you giving alternative accommodation to them?
That was
No.
provided in the act, so my lord, we did not contemplate, my lord. It's so far as the other tenants, we have not given, my lord.
So allow.
See, he's undertaking that the KMC he would give a report from the KMC. Such information is derived from such and such. And appellants, I undertake. The corporation is supposed to be here. Kindly. Two deeds of merger where the property has merged 100 square feet with 1/1B McLeod Street and 1/1A McLeod Street. It's merged. Now there are 5 owners. There are 5. He may be the litigants in this. But how will he give an undertaking once the property has merged?
But only thing, my lord, I will submit, my lord, kindly go through his written statement where these things have been stated.
They have not raised it after the decree was passed. They have gone the deed of merger in December 22 after the decree was
Have
passed.
they stated in the appeal court?
At the time of written statement, the property was not merged.
Nothing was
He has
stated in the
suppressed
appeal
this
court.
fact. He has suppressed this fact before this appeal court.
Only, my lord, to
Nothing
delay,
is there.
delay and delay, my lord.
Unnecessary. I do not want to stand in the way, but this is a fact, your lordship.
But let the
He
appeal
has
be kept
suppressed
pending,
it.
my lord. If
Let
there
me
is
file
any,
an
my lord,
affidavit, put the documents on papers. At least let me file an affidavit to the extent. I'll put the deeds on also there. Kindly allow me, your lordship, kindly allow me.
It's an order of remand.
My lord, the trial court decreed.
Order of remand.
The trial court directed vacating of the suit property within 18 months. That has been stated in the ordering portion that within 18 months we will give back the property, my lord. Now they filed appeal, my lord. The appeal court was of the finding that there is admission, but some vague admission. That is the finding, my lord.
Yes, yes.
Evasive admission. Evasive
No,
admission.
next is
That is the finding of the trial court. Admission is there.
Suit was decreed on the basis of
Building and rebuilding.
no. The trial court decreed the suit on the basis of admission.
Admission in the written statement. They admitted that they had certain talk with my predecessor in interest, my lord. They also entered into an agreement that they will vacate. Subsequently, father died, my lord. There was a lapse of time. Thereafter, my lord, the sons, my lord.
And after the decree is passed, they merge the property.
My written statement is annexed with the application for appropriate order, my lord.
Page number?
My written statement is at page 22. Relevant is page 24, my lord. My lord, in the very first order, my lord had quoted extensively from the written statement.
No.
Demolition.
Before, my lord, relevant is paragraph 8.
On certain terms.
No, there is specific denial at paragraph 27. Specific denial at paragraph 9. Specific denial at paragraph 10, 12. If your lordship takes the entire written statement, there are specific denials. Paragraph 19, specific denial.
Cannot be on 12/6, that's correct. The suit could not have been decreed on 12/6 because there are various conditions.
My lord, so far as the decree is concerned, my lord will kindly
That is the only ground.
Consider, my lord, 24, my lord, page 24, paragraph 8,
25K, page 25K.
25K, my lord.
The admission has to be read as a whole.
My lord, so far as they have, from the very beginning, they are saying that they are willing to cooperate, my lord. That
surprisingly, despite, because what they pleaded as an agreement, expressing their unequivocal consent in cooperating, such and such, they would be provided similar accommodation for commercial purposes, either as a tenant at a higher rate of rent or to acquire the said space on ownership basis upon payment of cost of construction. To the
Have
plaintiff.
provided similar accommodation. Similar means the same position, my lord.
So
They are commercial, they are shop, my lord.
upon completion of construction rebuilding, they would be provided similar accommodation.
Similar means
Commercial
similar.
purposes, either as a tenant at a higher rate or so.
That we are saying, my lord. He is either as a tenant or, my lord, as a ownership.
Despite such negotiation, the
That
plaintiff
was with
caused
the,
a notice of ejectment.
upon payment of cost. That we are not also saying that they have to
He
pay
is
the
also
cost.
not prayed for the to put
No,
us.
you agree? No.
Look, kindly take the written
Will you please
statement
allow
as
us to say?
yes, sorry.
You understand English and we also understand English.
Sorry.
What does K according to you mean? Read for yourself loudly. What K according to you means? Page 25. What does it mean? Please tell us. This is the condition. You said you demolish, we'll pay you higher, whatever the new construction is there. This was there, but when this negotiation was going on, they issue a notice of eviction to you. Now, so eviction means, in the sense, is a building for building and rebuilding. You agreed. So they are saying, yes, we'll provide you you inducted as a tenant at a higher rate of rent. Or you said you acquired the space. They are willing to give you this. So if they are willing, then there is an agreement. That is being recorded in this court.
That is on the basis of an agreement. Now, your lordship, kindly take into account the subsequent event. Once the decree is passed, they have now merged the property.
You are only interested to protect your right. We are protecting your right. That is what we are saying. We'll go by this K. This will form part of the decree for 18 months. If they do not give, they will pay you compensation and suitable accommodation. Stay down.
14, I'm appearing on behalf of the appellant. I'm led by Mr. Shayan Sinha, Lordship. Due to some personal difficulty, he could not come today. I'm praying for a day's accommodation, Lordship.
Appear on behalf of the caveator, respondent. Just give us one.
Lordship.
There are few defects which require to be corrected.
Lordship, the defects have been cured. The defect was, Lordship, that
The parties could not be verified in absence of the full cost title of the certified copy of the judgment and order. You have the full cost title.
My lordship, difficulty was that this appeal has come up at instance of other co-sharers. They have filed one application, lordship, for leave to file appeal. So, lordship, perhaps there was that
Lordship,
confusion. That is why that defect was there. In the stamp reporter has noted that defect. It was presented before the Lozima court on Thursday, lordship. Thereafter, the matter has been sent to court.
It was finally disposed of. Finally disposed of.
Yes, the injunction application was
Finally disposed of.
yes, it was disposed.
You are for?
I am for the respondent number 2 and 3.
You are for? I beg to appear for respondent plaintiff. Leave to prefer an appeal.
Lordship,
How you are affected?
Lordship, I am the co-sharer of the suit premises.
Made a party.
We were not made a party.
Somebody
Lordship.
should make an application there.
Lordship, if I may,
To prefer an appeal, would see. If this fact has to be brought to the notice of the court.
Lordship, it was brought to the notice of the court.
By whom?
This
Lordship,
is
by us. Previously, Lordship, what happened is this suit was preferred by the respondent, the plaintiff. It is a suit for
Are you a
specific.
party to the suit?
No, we are not party to the suit.
If you
Lordship.
are not a party to the suit, then either you should implead yourself there, or then you must say that your interest is being affected.
Previous round of litigation.
Lordship, there already has been a previous round of litigation, wherein it was informed to the.
Order 1 Rule 10 petition.
My lord, may I just clarify? I am the defendant there. Lordship, what had happened is that a similar ad interim injunction was passed on a previous occasion. These appellants, they had come up before this honorable court when challenging that order of ad interim injunction that it is an unstamped, unregistered document, could not have been looked into. My Lord Justice Harish Tandon, as his lordship then was, lordship was pleased to set aside the matter, set aside the impugned order. Lordship,
It will be hard.
yes, there was also a direction, lordship, that previous appeal was also at the instance of these appellants. That is their lordship. Without lordship impleading,
That was hard.
that was heard.
They were hard.
They were heard.
This order was passed after hearing them.
Yes,
Lordship.
if lordship may kindly
Pick up the impugned order.
You are
Lordship,
not a party to the agreement.
we are not party to the agreement, Lordship.
So your shares are not being affected.
No, Lordship, the agreement,
It
Lordship,
is the joint property
joint
of
property,
we are
undivided.
brothers and
Your
sisters.
shares are not affected.
Lordship.
Whoever has sold, they have only sold their shares.
Lordship, the partition has not been done.
Undivided share.
That is not mentioned in the order, Lordship, that it has been undivided.
Obviously, it would mean that whatever shares they have in the property, your shares
Lordship,
are not affected.
Lordship,
কালকে
the
এসে
kind,
সায়নকে আসতে দে, একবার সেটাই।
Lordship, days accommodation, Lordship,
Yes.
Mr.
Both
Sinha
parties-
will come.
This order is so far as the plaintiff and defendant is concerned. This does not affect your right. Because today, what does it mean? It means if the plaintiff transfer their share to someone else.
Lordship.
So this is between the parties. So you are not being affected. We clarify this. Take down. The appellant
Serial number 15.
Lordship, I'm for the applicant.
Yes, yes.
Lordship, probate proceeding was initiated. A probate proceeding was initiated by the executor, Lordship, and during the pendency of the probate proceeding, the executor died and it turned into a LA proceeding. Now the matter was filed before the district delegate at Barashat 6 years back. It became uncontentious. No objection has been granted by all the parties. If your Lordship will kindly, I have annexed the entire.
What is the order? What is
Yes, now your Lordship, at this stage, Lordship, at the stage of argument, when the probate is to be granted, the learned court found that it has no jurisdiction, therefore, it has returned the entire proceeding to be filed in before Barakpur, district delegate Barakpur. This is the order, Lordship. Now your
It has no jurisdiction, it has to
no,
go
your
there.
Lordship, at the time of filing of the application, it was taken because at that point of time, Barashat was not operational fully. Therefore, Barakpur. Now, your Lordship, since the district judge has the entire jurisdiction, it ought to have been referred to the district judge for transfer, Lordship, so that the district delegate at Barashat will take up the matter till the point it has reached. Now, if it is returned to me, I have to file. A de novo trial will be initiated, Lordship. Again, I have to.
What is the order?
Yes, Lordship. The impugned order is with the memo.
Not an appealable order.
A return of the plaint, Lordship. Therefore, I have return of the petition. Probate petition. Therefore, I have preferred an appeal. Order number 33, 26th of June 2025.
What is the date of the order?
Yes, 26th of June 2025. And
file the same before the appropriate court.
Yes, file the same. Therefore, I have to start from the beginning. 6 years have passed, Lordship, and the difficulty is most of the witnesses, they either stay outside of Calcutta or abroad.
Obviously, you start from the stage of the return. Obviously, it will.
Yes, that should be the order. That should have been the order.
Yes, yes.
It should have been transferred.
Yes.
No, I pay for the plaintiff defend respondent.
Lunch time for the yes.
No, no. Well,
Yes.
5 suits were filed before this honorable court in respect of premises number 46A.
Five suits filed in this court.
In this court. These 5 suits were all ultimately dismissed. However, an application for preemption filed in one of such suits was allowed.
28 days.
However, while passing the order of preemption by inadvertence that the decree did not provide that if it fails to make payment within a fixed time, what will happen? On that ground, an appeal was preferred. The appeal court modified the decree only to that extent by fixing a time limit. The original decree, when passed, provided that the preemptor who was a party and also happened to be the receiver over the property, was not to sell, alienate, transfer, or any manner deal with the said property for a period of 25 years. This was also confirmed by the appeal court. What happened was that after this and before the appeal court decree, the party receiver transferred a substantial part of the property in violation of the order of injunction to his son. To his son.
Okay.
The son, on that basis, created a deed of lease, created a deed of development, created a mortgage, etc., and also attempted to mutate that part of the property in his own name. I am the co-sharer. I own about 60% overall of the property. On coming to know of it, I applied before this court. I had the mutation cancelled, and by different orders passed from time to time, all the deeds created by the defendant receiver in favor of his son were all set aside. The mortgage was set aside. The mortgage to the bank was set aside. The development agreement was set aside. Lease was set aside, etc., etc. Now, what I find is what happened is that the son, in collusion with my learned friend client, inducted him.
The son of the receiver.
The son of the party receiver, in collusion with the learned friend's client, went and inducted my learned friend's client. Now, the problem was that since the deed by which the property had been gifted to the receiver's son was set aside, he antedated the tenancy agreement, but forgot that there was an already order of injunction passed by the trial court, which says that he cannot deal with and dispose of for the period of 25 years. Now, he filed a suit before the city civil court for declaration and for injunction against who? Against the son. When I came to know of it and attempted and got an ad interim order of injunction. When I came to know of it, applied there to be added as a party and asked for vacating that ad interim order of injunction. All other tenants have been, all other people brought in have been thrown out from time to time. Only he, according to him, he remains. Though two orders, two reports filed by special officers who were directed to inspect have not found him anywhere.
Found him?
Not found him anywhere in the property.
Not to be in possession.
Not to be in possession. He's not. Doesn't exist there.
Then what happened?
Now the trial court. I annexed all the papers. Annexed the decree passed by the trial court, decree passed by the appeal court. All the orders cancelling the transfers made from time to time. The trial court says no. He has filed a rent receipt given to him by his landlord. I'm contraring the order of injunction. Yes, it does say the order of injunction will be in only respect of the defendant number 1. I've been added as the defendant number 2. But he's going around showing that order of injunction to everyone and saying, see, there's order of injunction in respect of this property.
No, but what he is showing there is a different issue. What the order speaks is a different.
The order says,
so if he misuse the order and on that basis if he does,
my lord, I am the owner of the property. He claims to be a tenant inducted by someone who has admitted no right to title interest in the property.
Decided when the suit is being heard. So this is a limited order. This is a limited order.
This is an order. This will remain till the disposal of the suit.
Yes.
But my lord, he's got no right over the property.
He cannot be dispossessed without due process of law. That's the thing.
Not even by me. He cannot be dispossessed by his inducting landlord without due process. But his inducting landlord has got no right title interest in the property at all.
So you have now been impleaded.
I have been impleaded.
So in that you can also file a counterclaim and ask for his eviction on what you are saying.
There is no suit or any proceeding pending against me.
But I'm saying he's not there. There's the question of asking for his eviction.
Apart from the
I'm saying he's not there. My lord will kindly see this.
Apart from the
allegations.
Serial number. Serial number 17.
But 17 I appear for the appellants. There are two defects I have checked up. One is the delay. We had filed an application for condonation of the same, and another one is it was a mistake on our part. The valuation that has been set forth in the memorandum of appeal.
But have you filed section 5?
Yes, I have
Have you
filed.
served?
No, since the rectification was not made by it has not appeared. Hence,
Still is for 1 week.
kindly grants me.
Serial number 18.
18, my lord, I am for the application.
Yes, yes. House of
And directed, my lord, I have sub copy to the other side.
Have they received? The
Yes.
offer?
My lord, there is a delay of 5 days, my lord, and that.
Have they received? Have they received?
Yes, my lord.
Avenue service. Avenue service transfer.
Third September, my lord, they have received.
Destination delivered. Destination delivered.
So, in spite of service.
Special officer who has make an inspection and found that there is an shop room, and that is, my lord, we kindly look into this. And my lord, thereafter, my lord, the court on the date of final hearing, my lord, held that after considering that whether this can be considered at the time of hearing of the suit upon adjudication. And thereby, my lord, has rejected my applications and extended the injunction order of injunction passed by the court. Upon perusal of the applications filed under Order 39, written objections, counter affidavit, and affidavit against written objections filed by the defendant. No, I am the defendant. I filed an application under Order 39, Rule 4.
Why?
My lord, for vacating the ad interim order.
Why the reasons for variation?
The reasons for variations, my lord, that I have been carrying on business under the tenancy and the property which
Order 39 Rule 1 and 2 was decided on merits.
the order, no, ex parte order. That was passed, my lord, ex parte order restraining me from
Interim order.
interim order.
Yes.
That was, my lord, time to time extended.
Yes.
We initially, after filing the suit, my lord, after receipt of copy, we have filed an application.
Whether he has made, petitioner has made any false or misleading statement?
Yes,
What
that
is
is,
that? What is that misleading?
my lord, that in that room, my lord, there is, according to him, he has acquired a part of the premises by virtue of a deed of gift. My lord, we have contended that we have a separate shop room under the tenancy of my mother, and my lord, that room we are carrying on business. My lords, I have annexed all the documents in support of my, also in the present application, that I have a trade license, I have an, and my lord, the court has come to a conclusion that since the plaintiff's title is required to be proved, and my application has been rejected, my lord, on that score.
On which ground?
On that score, my lord, considering, kindly look into the order, it's
My lord, on the basis of a illegal, invalid, and an incomplete loan agreement, steps are being taken against a non-party suit for delivery and cancellation, delivery up and cancellation of a loan agreement, and for declaration that, my lord, of an agreement, a loan agreement. My lord, it's a written agreement. Loan agreement, loan, my lord. And also, my lord, for declaration that the plaintiff number 2 is neither a borrower nor a guarantor. On the face of it, my lord, on the basis of,
It's on 2nd September, what happened?
my lord, it's been kept on January, my lord, I'm told.
But have you not served them?
My lord, I have not served them, my lord. Your lordship will take.
2nd September, you should have served them and they could have come and you could have filed an order on that thing.
I agree, my lord. I should have done it, my lord. But your lordship will only take 2 minutes, nothing more. Your lordship will see the loan agreement. And today my prayer is only limited to the plaintiff number 2, not the plaintiff number 1. Your lordship will take the loan agreement, which starts at, my lord, page 24.
Is this a commercial suit?
Yes, my lord.
Then this court
My lord, I'm told, my lord, because there is no commercial bench, my lord, as of the order which was passed was not by the commercial bench. Therefore, my lord, the matter has come before your lordship, my lord. I mean, it's a departmental issue, my lord. It can't be taken up by the commercial bench, the appellate commercial bench, because, my lord, it's not been passed by the commercial court in city civil court. Well, if your lordship only takes 2 minutes, if your lordship takes page 24, this is the loan agreement. It's undated, unsigned.
This must have been assigned with the.
My lord, I am instructed that there is no bench yet assigned.
Keep it tomorrow.
Tomorrow, my lord.
Serial number 20.
I'm for the respondent.
I'm for the petitioner, Lordship.
You're for the petition.
Yes, Lordship. Appellant. Lordship, on the last occasion directed to serve the memo of appeal. It has been served, Lordship.
What is the improved order?
20. That's the impugn order. Impugn order.
So order 39, rule 1 and 2 was dismissed.
Yes. Yes, Lordship.
You're for the respondent.
Yes, my lord.
But if there are some record, it will show that they are in possession of the property.
My lord,
So,
yes,
so their possession cannot be disturbed if the suit is decided.
my lord, the thing is that, my lord, what they have suppressed is that there are 5 suits pending between the parties. And yes, my lord, this is the, my lord.
But this was not the thing which was taken into consideration by the trial court. What you are submitting.
Yes, my lord.
This fact, it was not the
My lord,
fact.
that has been verbally submitted before this court because, my lord, this.
No, because the trial court is not there. If person in possession, you may evict him, but it must be due process of law.
Yes,
and
my
there are some records which suggest that they are in possession.
Yes.
So this interim order will continue till the disposal of the suit.
My lord, the thing is that, my lord, first of all, your lordship has, my lord, recorded that the alleged deed on which reliance is placed by the defendant has no value. My lord, this will affect, my lord, the merits of the case. Because, my lord, this suit itself is hopelessly time barred.
You are the defendant of the plaintiff.
No, so I am the defendant. Here I am the defendant.
Respondent.
In the suit.
In the suit, I am the defendant.
You're the defendant. What is the date of the alleged deed?
1972. Registered on 1972. The suit was filed in 2019.
Lord, I am for the respondent. My lord has called for a report from the Kolkata Municipal Corporation.
I am appearing for the Kolkata Municipal Corporation. May I file my
Madam?
may I file my report? Your lordship directed me to file a report.
No. Last time we passed an order, no one was there.
Madam, your lordship, since we were not represented as per your lordship's direction, your lordship directed that in the meantime, we should
So last
comply.
time why no one was there?
Yes, my lord, there was a miscommunication amongst the department officials, for which we could not appear before the lordship on the last.
Have you seen the report?
No, I have not seen, my lord.
See the report.
Yes, my lord.
The report.
My lord, the contents of the report, my lord, I am not admitting. The contents of the report.
Said that you can challenge the independent procedure.
Very well, I'm grateful.
That's right. Correct. Definitely then.
Yeah, well, the facts are like this.
we had to develop a complex. And my lord, we have done it. Now, there is a penalty provision 4 years after the last sanction.
Who is appearing?
We have served them both. Lordship, we want a practical solution here, but this will, because we have served in both the matters, we have filed affidavit of service. The second appeal is the one. Serve होएगा sir, तो तुम देखे ना ये बात, service has been effected. Lordship can make an order for us to serve once more and keep it.
Speed post and hand service.
Speed and hand, Lordship can, because I would, because I want a solution, my lord, that's the whole thing. Because the flat buyers are not getting their conveyances now.
But
Yes, I know their presence is required. Lordship, kindly make an order, keep it on Thursday. We shall. Can you serve once more? Thursday after Thursday. Lordship can direct us to serve once more and keep it on Thursday. Then I shall in their presence only.
affidavits for that.
They don't have.
Oh, there's an order also. I would like it to be involved in their presence. Honestly, the Lordship's order says that it will be taken up in their absence also, but I would like personally for the matter to be resolved before your Lordship in their presence. Last order says so, but his Lordship says.
HON'BLE is the solicitor, no.
HON'BLE, I have not done any matter from.
So Arindam Banerjee was appearing. Senior counsel.
Arindam Banerjee also, I have not seen him regularly appearing for. Well, we can serve once more, or keep it on Thursday, we'll take a try, or else I shall ask for orders in their absence.
No, but what is the order?
But the order is just plain adjourn, not. Not
The second order was refused. So
second one, Lordship kindly takes a look at the.
the order is of 17 May.
Well,
The order you understand.
the next appeal, well, because that appeal was pending, we moved another application there for execution of deeds. That is on 9th of June order, 9th June order.
9th June, there is no order of 9th June.
Lordship, that is the second appeal, my lord.
It's 30 May.
Well, the first appeal, Lordship kindly takes a look at the first appeal. Lordship kindly comes to the second.
The trial could decide this.
This, my lord, execution of the lease deeds are not happening. That's the whole problem.
That's there, but that is for the.
Lordship kindly comes to the second page of the first order.
When is the next date fixed?
24th November.
September was a date.
So better on 24th.
Lordship, here it says now the prayer of the plaintiffs is that the defendant should be restrained from taking any coercive steps in the matter. No person can be restrained from taking any steps in regard to legal and valid instrument, particularly one in which the plaintiff was a willing party.
That is why they wanted to know, the court wanted to know that whether the steps taken by them was coercive or not, and whether in the facts and circumstances of the case, this step was they could take.
Correct, ma'am.
Which of these? That's why I'm saying that if it is fixed on when.
November, but thereafter what happened was this was administrative demand. We moved this application. They made a demand. We moved this application. So then.
That is also challenge under.
Yes, that is the first appeal. Now thereafter, my lord, what they did is that they refused to pass another order refusing to execute the leases which they have allotted to the flat buyers by their own lottery system. They have allotted to the flat buyers, and those flat buyers have paid the money with home finance, and now they want their lease deeds to be executed. They are saying because they have a grievance against me, so they will not execute the lease deeds in favor of. No, that is my second appeal. Commercial suit.
This is not a copy of commercial suit.
Well, this was the lordship. That is because of my lord's judgment and that Ambala Sarabhai on the day when the contract was entered into, this was vacant land and purely resident. This was a vacant land on the day when we, and it's a residential complex. That is may not be the criteria, but when the agreement was entered into, at that time, this was a vacant land. This was not being used for commercial purpose.
Subsequent order, where is the
My lord,
where is the subsequent order?
subsequent order isn't it the second appeal? Right, the appeal action.
When we went back to move the second injunction.
When we moved the second application,
The other side appeared, court said they've appeared to give injunction. Couldn't hear nothing.
could the prayer power, second application. Prayer application.
The password. Workman's compensation.
Compensation.
Take it as connected. Yes.
My lord, I am for the appellant insurance company.
কিন্তু এখন তো 3 ঘুরে এলো।
Company and the employer and the insured has not been made liable to pay. So I, as the indemnifier, is not liable to indemnify and and
There was a section 5 that was allowed.
my lord. And moreover, this was an injury case, my lord, where in 2005 the workman suffered injuries, and thereafter, during the pendency of the case, he died. His wife died earlier to him, and thereafter, the married daughter was substituted. But according to the Workmen Compensation Act, my lord, the married daughter who is not a minor or who is not dependent on the income of the father or is a widowed daughter cannot claim compensation. And this is an injury case, my lord. And moreover, the injury was not according to the schedule of the Workmen Compensation Act. Injuries are not according to the Workmen Compensation Schedule, my lord. We have that Rajkumar Ajay Kumar case, my lord already knows, my lord. I have a copy, will I give, my lord? These two judgments, my lord.
That's what you say.
My lord, 2 questions has been raised. First question was the relationship between the employer and employee relationship. That question has been raised by learned friend. So that question,
Admittedly, this person was the driver of the.
my lord,
Not admitted, my lord. The employer insured did not come. No iota of
Insurance policy, what does it say? The driver was insured or not?
insured.
driver.
Covered by the insured.
My lord, the employer did not come before the commissioner.
But the
Yes.
insurance policy will speak for itself.
Yes.
Insured, yeah, my lord.
So it's for the benefit of the workman.
My lord.
For the benefit of the
If
work.
he has suffered an injury in course of employment, liability remains of the insurance company.
My lord, my lord.
But the
Yeah, this you have decided your other matter. Why don't you give that order? You finish it up. Give the other. Give the order.
my lord,
Order, give it.
my lord, but the injury is not 50%,
That's a different issue.
and the daughter cannot claim compensation here. Married daughter, major married daughter.
Well, originally the injured himself filed the claim.
Give that order. Give that order.
My lord, which order, my lord?
That is the
Order. Lord.
reform is down. That order, that matter you move.
My lord, I could not follow.
Which matter you move, that matter you move.
তুমি কবে মুভ করেছিল
কবে মারা গেছে?
তুমি কবে একটা ম্যাটার মুভ করেছিল ম্যাটার ডিসমিস করেছিল on the ground.
What you are showing?
No, my lord, those matters in which you, my lord,
Yes.
it was rejected. Those those appeals became infructuous. That's why I did not fight.
But here also. So yes, so far as the married daughter, the PRT has a point.
Married daughter, not also minor.
When accident was taken place
2005.
and at that time you are the unmarried marriage was taken place. I want to know.
Marriage did not take place.
Marriage did not take place, but that time the injured person was there. He claimed compensation for
himself
himself.
filed the claim.
He filed the claim, and in
Similar-
2015 he died. At that time, this
So whatever compensation he will get, he will follow the succession.
My lord, my lord.
Yes.
There's a
my lord, but she was not dependent. She has to prove her dependency and
At
the
that time, she
injury. The percentage of injury is also.
No, the claim amount, suppose Akita is suffering injury. So it will be the earning capacity.
My lord.
It will get to the dependent, no doubt. But By that time, I died when this matter was finally decided. The compensation has to be to the legal heirs.
No, dependents, according
To
to
the
the
heirs or
doc-
dependents?
here,
Dependents.
here in WC Act, according to only it will go to the dependents.
Dependents means they must be
Because
heirs.
there is a distribution case after the everything is done, commissioner has to find out whether they are dependent or not.
When the case was filed,
2005.
2005.
2005, and it takes.
Then they were unmarried.
No, after when this person, injured person died, it was in 2015 and the order has come out in 2024.
The 2005 claim case,
My lord.
they were all dependent on the date when the
Claim was filed.
But that time, the person only, the injured person.
You are only interested that how the compensation money and how this is distributed is for the commission, the court to decide. And this point was never asked before the trial, before the commission, first court. When the matter
This was only in
Decided
2024.
on the date of not filing of the claim. What is the position?
At that time, she was dependent.
Serial number 24.
My lord, in this matter, I'm being led by Mr. Shroff, my senior. Sorry, my lord, in this matter, I'm being led by my senior, Mr. Vinay Shroff. My lord, I'm praying for a week's accommodation, my lord, in this matter.
Sit down.
ওরে দিয়েছে ওরে দিচ্ছে না দাদা
ইনকাম ট্যাক্স একটা দিতে হবে আমাকে।
Your Lordship, Mr. Sharma is here. I'm for the respondent.
Yes.
I'm being led by Mr. Muzumdar, Your Lordship.
What is your ground of challenge?
Well, we have challenged that the assessment order has been passed. Well, he has traveled beyond the show cause notice, my lord.
Sorry?
He has traveled beyond the show cause notice. As per the scheme, my lord, there is an assessment scheme framed under the Income Tax Act. There is right now, after 2019, this faceless scheme was introduced, my lord. There is a provision 144B was introduced, my lord. Section.
But, they say, as it appears from the impugned order, that on the date that was fixed for hearing because of the video conferencing facility not working, they could not address. So if that be the situation, then, and the order was passed on 20th January 2025. So there is a provision for appeal.
Yes, madam.
Correct.
There is a statutory appeal.
But then again, it's a national justice violation. So let them give the opportunity and hearing matter.
And statute also provides so, my lord. 144
Because you
6
see,
Roman 7.
it has happened not because of them. They were present. So for these technical snag glitches, they could not.
But my lord, what I have ascertained from my learned friend, the submission, he is going into the merits of the order.
No, I am not.
No, show cause, he's saying
No,
that the assessing officer had gone beyond the scope of the show cause notice.
This is also natural justice.
That's there. That's there.
That, my lord, then he has to go.
Yes, that absolutely. But whether he has a right to raise it before the assessing authority, I can always go before the authority and say that this is not within this, you cannot decide. So this I can argue. What he said, he could not place his case. And according to him, because the order has come in between.
Yes.
The assessment order possibly has come in between, correct?
No, my lord, he has made submissions before the assessing officer.
No.
His replies were considered.
But that kindly, my lord, I think my lord, learned friend is saying the contrary to the record. Kindly come to page 301.
I will show them, my lord.
Volume 3.
I just go by the impugned order.
Yes, sir.
The impugned order says, I find that the impugned order has been passed on 20th January 2025. It must be an order passed by the assessing authority.
Yes,
This
madam.
is a faceless assessment scheme.
Yes,
It's a
madam.
faceless assessment.
It is assessing officer.
From the aforesaid order, it would transfer the details of opportunity of hearing given to the petitioner have been noted. The petitioner complains that on the scheduled date, virtual hearing. So what he wants basically is that since that order was passed without giving him an opportunity of hearing, so that order should not be implemented. That is, he's not going to the merits. So we limit to that only. We limit to that effect only. Because we are not saying whether he can still retain the order after hearing them.
No further submissions will be. No further submissions by a written submission
what
should
does
be
it mean?
allowed.
Sorry, what? No further?
My lord, the SSC had been given the opportunity to place his case. By way of written documents, the SSC has placed his case. Only the issue was that the personal hearing.
Yes.
Personal hearing.
That's what I'm saying, personal
only
hearing.
To that extent, my lord. Not any further submissions by way of written documents or.
No. What I am submitting, I can also give a written form. That's helpful for the assessing authority. Take that.
Well, he is saying saying that the assessing officer is bound by the only personal hearing. If the personal hearing, during the personal hearing, if I ask for some document to submit, well, I have the
No, that is
liberty
for
to
the
file
assessing authority to
submission.
decide. I am
He
not
is
going into this.
he is trying to
Take down.
confine me to that only. The statute is saying otherwise, my lord. Section 144B6 Roman 7.
The order, no, the prayer for remand to the National Faceless Assessment Center for fresh hearing was turned down in the writ petition Yes, you are not appearing? ভুল ম্যাটার দিয়েছে আগে ম্যাটার দে No, you are not appearing. Watch it. Sorry.
সেই ভদ্রমহিলা
বাবা
সুশীল
Your Lordship, I am appearing for the respondent number 126, Your Lordship. Your Lordship, I am praying leave to file cross objection, Your Lordship, because I am.
Before that, my lord, if I just could take your lordship, because after service, my lord, one copy has been returned to me by saying that one of the respondent passed. So I'll just take out an application for substitution.
You have filed it?
I did not yet. I just got that, my lord. I have got the affidavit of service only. I'll just
Appeal
check.
against decree.
One of the respondents, which is respondent number 10 in the appeal.
Decree.
Preliminary decree in a partition.
Yes, madam. I'm sorry.
Stay down.
For the respondent number 1.
My lord, I am appearing on behalf of the appellant, my lord. My lord, due to illness, learned advocate is unable to appear, my lord. Due to illness, my lord, learned advocate is unable to appear before your lordship, my lord. So I am bringing, my lord, 2 weeks time, my lord.
2 weeks time.
2 weeks.
That will be vacation. Who is for the appellant?
I'm
You are
for
for the
the-
appellant. Then after vacation, take down. On the prayer of the land.
Mirror. The fact is that Mirror, we have complied with the order passed.
Who is appearing?
Nobody is appearing. No caveat has been lodged, Mirror. But I am most humbly praying before your lordship.
We dismiss the appeal for non-removal of the defects.
Well, we have complied all the formalities given by the Logima court, and thereafter, Mirror, nothing. I filed an application on compulsion.
Application.
Lordship kindly restore this matter and kindly give me 2 or 3 days time so that I can move before the honorable court for admission of the order for the judgment of reversal. I have annexed all the documents with regard to my wife's illness, learned advocate on records. I have written everything, Lord. As such, most humbly praying. Beseeching your lordship.
By after the application of card.
They have deposited the court seals, everything.
August. 25th August.
I have already filed the
report reach. 11 July 2025. August করেছি। Sure.
I'm for the respondent. I'm for the appellant. On the last occasion, it was found there is some mistakes on degree, and we are directed to take the necessary steps before the landed trial court. We have taken already taken steps for necessary correction of the degree, but the landed trial judge is delaying the matter. We have
the matter.
The next date before the learned trial judge, 18 September 2000.
What happened, Lord? May I just narrate before your lordship the respondent number 1? Lord, his heirs are already on record. He died. Lord, it has been written, Lord, in the memorandum of appeal that the respondent number 1 has died. So, Lord, his name has to be expunged, for which my learned senior friend has to take out an application before this honorable court. So far as regards respondent number 2 and 3 is concerned, Lord, they have already been substituted and expunged before the court below, but wrongly their name has been appearing, Lord, in the decree of the trial judge. So these two necessary corrections, so far as regards respondent number 2 and 3 is concerned, has to be carried out before the trial court by correcting the decree. So far as regards the respondent number 1 is concerned, my learned senior friends has to take out an application for yes, subject to correction by my lord.
Who are the years of deceased respondent number 1?
4 and 6.
4 and 6.
4 and 6. But কি বললে 2 and 3 টা কি বললে? কি বলতে থাকতো? হ্যাঁ? আমরা আমাদের 150 টা পেয়েছি। আমরা কি করেছি?
What's the name of the respondent number 1?
It has been captioned Nirmal Kumar Mukherjee deceased as appearing in the memorandum of appeal.
As it is in the degree.
So his years is 4 and 5.
4 and 6.
4 and 4 and 6. এদিকে অলরেডি রেকর্ড তো বাদ যাবে ডিগ্রিতে কারেকশন
I'm relying upon Article 59.
Yes, so but
issue number 3, my lord, along with additional issue number 8, kindly once looks at if your lordship is taking the CAN application, page 81 of my lord's brief, how the trial judge has dealt with this. Issue number 3.
The deed of settlement was challenged after 3 years.
Long after, my lord, 144 proceeding.
So what injunction they are claiming?
Now, my lord, that has already been vacated now.
So the appeal has to be heard.
No. Injunction application to be heard.
The order of injunction was vacated.
Interim injunction was vacated. And they filed written objection against the injunction application.
The coordinate bench has vacated it because there was admittedly the suit is barred by limitation. Admittedly. So if the suit is admittedly barred by limitation,
we can expedite the process of
my lord.
We expedite the process of hearing of
No,
the
my lord. They were asked to file written objection against the injunction application,
done that,
and we have filed evidence in reply. We have already copies heard. Evidence in reply.
Appeal has to be heard. No injunction.
Now, my lord, in the meantime, if they change the nature and character of the property and they create a third party's interest.
Suit for partition and the cancellation, because the primary relief is the cancellation of these deeds.
No.
Otherwise, the partition
is
correct.
It is not under Section 68 of the Limitation Act. We paid relief for declaration. We did not pray for cancellation.
Except the schedule, the prayer at page 49 of my lord's brief can.